Good morning, everyone. Today, we would like to thank Professor Jonathan for giving us this opportunity for this presentation. Today, our group members, Anwar Wahid, Suhag Mia, Deepu Mia, and Rohan Matthew, would be presenting the laws undertaken in particular cases and the scenarios behind those. So, before starting off, I would like to define law. What is law? Law are the set of rules a country or an organization must follow, and if not done so, will be enforced by imposing a penalty. It helps an organization work in a best possible manner. Today, our group will be discussing about two laws and the corresponding cases. The first case, which is the Mazda CX-9 case, it is related to the contract law, in which the organization gave a false advertisement and did not reward the winner and withdrawed the rewards at the final stage. Second of all, the case of Costella Bank and Sparkling Private Limited, which uses the corporations law, in which an employee, Sarah, spent an excessive amount than what was mentioned in her contract, even after her tenure was over. In this case, the Costella Bank launched a case against Sparkling Private Limited for stopping the repayment of loan. Now I would like to call upon Anwar Wahid to carry on the presentation with the first case and elaborate upon the first case. Thank you.
First of all, I would like to thank Rohan. And here now we will discuss about the cases. The first issue is about the Sue Burger, who had given a false advertisement about a competition in which anyone who wins a golden ticket for redeeming 50 token will get a gift of Mazda CX-9. But here the firm had failed to mention that there was only one CX-9. Apart from that, the firm misprinted the golden ticket and awarded the CX-9 to another person. And also the firm had come to know about the situation and they had withdrawn the competition, which had already went a long way. Now we will discuss about the rules which have been used over here. In these cases, the rules used has been Australian contract law and also the Australian consumers law. In Australian consumers law, mainly general protection is mainly for the general protection. In chapter 2 of ACL established the general standards of business conduct, misleading or deceptive conduct, unfair contract terms, and unfair practices are mainly being used here to highlight this case. Now we will continue with the application. In this case, Mickey, it had been observed that he is a loyal customer and he managed to eat 50 double-sized burgers for winning the prize, and later he was hospitalized due to overheating. Thereby, Mickey became sick as the company issued no warning towards the health hazards, and the company is liable to hold guilt for not giving health hazard to the customers. The company may face legal action under the Australian contract law if Mickey sues the firm. However, the company can also safeguard their advertisement by mentioning it is a printing error, but the company can face legal action if Mickey sues the firm for sure. In that case, it's better for the company to settle the dispute or resolve the problem by settling him with the price. In the other case, Brett has not bought a single burger and he has managed to collect the golden coins from the trash. So in that case, company can prevent themselves for not having the proper documentations with them. And apart from that, when we lead to the conclusion, it can be concluded from the above section that Sue Burger needs to have committed a service offense by providing deceptive content in the advertisement and manipulating the customer for personal gain. Thereby, the action of the company is again against Australia's contract law and Competition and Consumers Act 2010. Thank you, and now I would like to invite Shohag to continue with the same presentation.
Thank you, Anwar. Now I would like to continue the second case. The corporation law has been discussed through the IREC method. The issue in that case is that there is a legal dispute between the Costello Bank and the Sparkling Pty Limited. The expiration of the contract and recognition of it has not been done in writing. Hence, the legal obligation can hold the company guilt but not Sarah. Rules. The rules of Australian corporation law can be used in that case, and it will bring the suitable conclusion. The Corporation Act 2001 can be applied as it helps to see the corporate contract and the other factors. As Sarah was not in the position but she continues to hold the position in that case, Australian contract law can be applied for misconduct done by her. It can be concluded from the analysis that the loan officer of the bank was not aware about the internal contractual problem. Sarah has conducted the transaction on behalf of the company. The internal conflict cannot be shown as the proof of getting away against that obligation. In that case, the bank has full authority to hold both company and Sarah equally for negligence and not to commit fraud by not paying the loan amount. The firm cannot stop the repayment. In conclusion, it can be said that with the help of Australian corporate law, the bank will be able to win the case easily. Now, I would like to call my friend Deepu Mia to conclude the presentation.
Thank you, Sohag. I am here to conclude the presentation. To conclude, it can be said that the two laws have been used in both the cases that helps to bring out the best conclusions as far as the requirements. By using the contract law, it is found that there is a misleading or deceptive conduct, unfair contract terms, unfair practices. By applying these conditions, Mikey would receive justifications for the act against Sue Burgers. In the second case, Corporation Act 2001 is applied. There were misusing of positioning, breaching of contractual term, and negligence by the board of the company. By using the corporation law, the bank will able to get the repayment of the loan. With the applications of corporation law, the Sparkling Limited Company should be able to forward the interest that is rested upon by the bank. And thank you all.